Good evening, students. Today, from the examination point of view, our Brainz channel has already released the most likely questions for the benefit of the LLB students. That too, first semester students, because they don't know how to write the answers. And in this corona period, for most of the students, the classes has not been conducted fully, and I know the problem. And here, with regard to the problem itself, that is illustration problem itself, majority of the students, they don't know how to solve the problems. They don't know the method. And here, and majority of the students, they will lose the marks because, you know, under 80-20 scheme, 50 marks is for the theory questions, 30 marks for the problem-based questions. And here, you will be capable to solve all the theory questions. But with regard to the problems, majority of the students, they will lose the marks because of their ignorance in solving the illustration-based problems. Here, with regard to the how to solve the illustration problems, we have already made several videos with regard to the how to solve the problem-based questions or illustration-based questions or easy steps in solving the problems. You can look into the earlier videos. But however, from the examination point of view, I thought of giving you certain illustrations because now we don't have absolute time now. It's not possible. So here I am not going to discuss what is the issue, what is rule, what is analysis, what is conclusion. That means that will be IRAC method. That means that is internationally accepted illustration based problem solving method. And here you can look into the other methods will also be there. That is ILAC, fact, issue, provision of law, analysis and decision, or reason for decision making. These other method is also there. But from our Brainz channel, for the easy solving of the problems, for getting the fullest marks in the exams, I have chalked out certain a very easy way of attempting the questions. That is provision of law, question of fact or question of law or issues, or rule of law, and logical reasoning, and the mature judgment or the methodology. So this is the method we can see here from the examination point of view. And here I thought of making you very easier with regard to the attempting the questions with regard to the illustration based problems. Here what you have to do, you have to know which are all the illustration based problems, because if you see the previous question papers, you can come to know which are all the problems are available. So here, if you see the earlier problems, you can easily see, and you know the what you can answer for those questions also. But you don't know how to write how to solve the problem. That is the main problem for the students. That's why I have selected only one problem. Here, absolutely I can do almost all the problems in the Contract-1, beginning from the offer and acceptance till the end of the Contract Act. So here I will, for the example purpose only, I have selected only one problem, so you can able to follow. And in this video only, I have given which are all the important case laws with regard to the Contract-1. So that also you can easily see, because what happens with regard to the Contract-1, it is full of case laws only will be there. So for solving the illustration problems, you should know which are all the case laws, from which topic it will come. First you should know the case law, and you should know the sections. Then you should know the provision of law, that is provision of law and the sections. All these things you should have idea. Otherwise, you cannot able to solve these illustration problems. just if you write yes or no, the plaintiff can claim the damages or does not claim the damages. No, the valuer, he will give the mass. So for very urgent purpose, I will solve only one problem for your benefit. And if I find time tomorrow also, I can solve other problems. I hope you can understand. So here, one illustration problem has been given. Here, a Kalabhavan was agreed to be let out on a certain day. A Kalabhavan was agreed to be let out on a certain day. Before that day, it was destroyed by fire. Discuss the consequences. So in this way, the question has been given. That means there is some bhavan. That means, you know, there are mandiras will be there, Rangamandira, all those things will be there. And it is meant for giving the for let out. Let out means for the daily rent. That means in order to conduct any functions, the bhavans will be available. So here there was some agreement was there between one party and the other party with regard to the engaging that Kalabhavan for a certain day. And before that day, it was destroyed by fire. Discuss the consequences. That means that the bhavan was destroyed due to some fire accident. It may be some fire accident. So it was destroyed. So here we have to discuss the consequences. Likewise, in this regard only so many case laws will come. So many the examples will come in the examination. Either it may be for with regard to destruction of the instrument or with regard to the minors the agreement. So today I can discuss only with regard to this aspect. Here we can the provision of law will apply here. Section 56 of the Indian Contract Act. Here it will see, we will see under the waiver. So here there is a discharge by impossibility of performance. Here you can see the bhavan was destroyed by fire. The bhavan was destroyed by fire. It is not possible to perform the contract. Here there are certain things are there. That is, first one is effects of initial impossibility and effects of supervening impossibility and declaration of law, change of law. So like certain conditions are there under section 56, that is a waiver of the contract. So here we can see first aspect, that is effects of initial impossibility under section 56. Here that is the provision of law we have to write. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ ಈ ರೀತಿಯ ಒಂದು ಪ್ರಶ್ನೆಗಳನ್ನು ನಿಮ್ಗೆ ಬರಬಹುದು. ಯಾವುದರಲ್ಲಿ ಈ ಕರಾರು ಅಧಿನಿಯಮದಲ್ಲಿ ಸುಮಾರು ಈ ರೀತಿಯ ಒಂದು ಉದಾಹರಣೆಗಳು ಮತ್ತೆ ದೃಷ್ಟಾಂತಗಳು ಮೊದಲಿಂದ ಅಂದ್ರೆ ಕರಾರು ಪ್ರಾರಂಭ ಆದಾಗಿಂದ ಕಡೆವರೆಗೂ ನಿಮ್ಗೆ ಈ ರೀತಿಯ ಒಂದು ಉದಾಹರಣೆಗಳು ಅಥವಾ ದೃಷ್ಟಾಂತಗಳನ್ನು ಕೊಡ್ತಾರೆ. ನಿಮ್ಗೆ ಇದನ್ನ ಬಗೆಹರಿಸುವ ವಿಧಾನ ಗೊತ್ತಿರಬೇಕು. ಇದರಲ್ಲಿ ಏನಂದ್ರೆ ಈ ಒಂದು ಕಲಾಭವನ ಇರುತ್ತೆ ಬಾಡಿಗೆಗೆ, ಅದನ್ನ ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರುತ್ತೆ. ಆದ್ರೆ ಯಾವ ದಿವಸ ಅದು ಬಾಡಿಗೆ ತೆಗೆದುಕೊಳ್ಬೇಕಾಗಿತ್ತು ಆ ದಿನದ ಹಿಂದಿನ ದಿನಾನೇ ಆ ಕಲಾಭವನ ಸುಟ್ಟೋಗುತ್ತೆ. ಇದರಲ್ಲಿ ಅದರ ಮುಂದಿನ ಪರಿಣಾಮಗಳನ್ನ ತಿಳಿಸಿ ಅನ್ನೋದು ಒಂದು ಪ್ರಶ್ನೆಯನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ನಾವೇನ್ ಬರೀಬೇಕು, ಒಂದು ಮೆಥಡ್ ಇದೆ, ಯಾವುದು IRSA ಮೆಥಡ್ ಇದೆ, ಇಶ್ಯೂ ರೂಲ್ ಅನಾಲಿಸಿಸ್ ಕನ್ಕ್ಲೂಷನ್. ಇದರ ಬಗ್ಗೆ ನೀವು ನನ್ನ ಹಳೆಯ ವಿಡಿಯೋಗಳನ್ನ ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗುತ್ತೆ. ಇವಾಗ ನಮಗೆ ಪುರ್ಸೊತ್ತು ಇಲ್ಲ, ಇದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದ್ರೆ 1 hour ಆಗುತ್ತೆ, ಮತ್ತೆ ನಿಮ್ಗೆ ಎಕ್ಸಾಮ್ ಪರ್ಪಸ್ ಇಂದ ಹೆಲ್ಪ್ ಆಗಲ್ಲ. ಅದರಿಂದ ನಾನು ನಮ್ಮ ಒಂದು ಮೆಥಡ್ ಯಾವುದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಅಂದ್ರೆ ಕಾನೂನಿನ ಒಂದು ವಿಷಯ, ಕಾನೂನಿನ ಒಂದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಅಂದ್ರೆ ಕಾನೂನಿನ ಒಂದು ನಿಯಮ ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ, ಕಾನೂನಿನ ಉಲ್ಲೇಖ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂದ್ರೆ ಇದು ಕಲಂ 56 ಭಾರತೀಯ ಕರಾರು ಅಧಿನಿಯಮದಲ್ಲಿ. ಎರಡನೇದು ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್, ಕ್ವಶನ್ ಆಫ್ ಲಾ, ಇಶ್ಯೂಸ್. ಸೊ ಹಿಯರ್ ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ವಾಟ್ ಈಸ್ ದ ಕ್ವಶನ್ ಆಫ್ ಲಾ, ವಾಟ್ ಈಸ್ ದ ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್, ಇಶ್ಯೂಸ್. ಸೊ ವಿ ಹ್ಯಾವ್ ಟು ಫ್ರೇಮ್ ದ ಇಶ್ಯೂಸ್. ಅಂದ್ರೆ ನಾವು ಸಮಸ್ಯೆಗಳನ್ನ ಹುಟ್ಟಾಕೋಬೇಕು. ವಿ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ದ ಇಶ್ಯೂಸ್ ಆನ್ ಅವರ್ ಓನ್. Here, no doubt in illustration they have given the problem, but we have to make the issues on our own. Here, whether the contracts hold good, whether the plaintiff can claim damages. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಒಂದು ವಾದಿ ಏನು ತನ್ನಗಾದ ಹಾನಿಯನ್ನ ಒಂದು ಪ್ರತಿವಾದಿಯಿಂದ ಪಡೆಯಬಹುದೇ, ಈ ರೀತಿಯ ಒಂದು ಕರಾರು ಒಂದು ಸಿಂಧುವಾಗುವುದೇ, ಈ ರೀತಿಯ ಸಮಸ್ಯೆಗಳನ್ನ ಅಂದ್ರೆ ಈ ಯಾವುದು ಸಮಸ್ಯೆಗಳನ್ನ ನಾವೇ ಅದನ್ನ ಒಂದು ಬರಿಬೇಕಾಗುತ್ತದೆ. ಇದರಲ್ಲೇನು ಪಿ ಅಂದ್ರೆ ಪ್ರೊವಿಷನ್ ಆಫ್ ಲಾ ಅಂದರೆ ಒಂದು ಕಾನೂನಿನ ಒಂದು ಉಲ್ಲೇಖ. ಎರಡನೇದು ಒಂದು ಇಶ್ಯೂಸ್ ಅಂದರೆ ಇಶ್ಯೂಸ್ ಅಂದ್ರೇನು, ಸಮಸ್ಯೆ, ಏನು ಸಮಸ್ಯೆ ಇದೆ, ಪ್ರತಿವಾದಿ ಮತ್ತೆ ವಾದಿಗೆ ಏನು ಸಮಸ್ಯೆ ಇದೆ ಅದನ್ನು ಬರೀಬೇಕು. ನೆಕ್ಸ್ಟ್ ಒನ್ ಈಸ್ ರೂಲ್ ಆಫ್ ಲಾ, ಸೆಟಲ್ಡ್ ಲಾ ಆರ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಸೊ ಹಿಯರ್ which is the rule of law, which is the settled law? The settled law is under frustration of contract. Here Taylor versus Caldwell, here also the same thing has been discussed in this the case law. The same concepts we can see under the case law of the Taylor versus Caldwell. Here we have to see these things and we have to discuss. Here the performance of contract is not possible by the defendant because the subject matter itself has been destroyed. So that's why this is not possible by the defendant to perform this contract. So this we can see under the Taylor versus Caldwell. In this case also, the doctrine of impossibility has been applied where the actual and specific subject matter of the contract has ceased to exist. So this we have to write under the rule of law, settled law or court judgments or decided cases. ಅಂದ್ರೆ ನಿರ್ಧರಿತ ಪ್ರಕರಣ ಅಂತ ಬರೆದು ಇದರಲ್ಲಿ ನಾವು ಈ ಟೇಲರ್ ವರ್ಸಸ್ ಕಾಲ್ಡ್ವೆಲ್ ಅಂತ ಬರೀಬೇಕು. Then we have to write the logical reasoning. Here we have to write all the things with regard to the provision of law, question of fact, rule of law. Here under logical reasoning we have to write complete all these things. The problem given in the initial case is very similar to Taylor versus Caldwell. In this, the doctrine of impossibility will apply because according to section 56, the Indian Contract Act, the contract cannot be enforceable under specific ground of frustration. So this we have to discuss. So under the issue rule analysis conclusion also same method. Here we have to frame the issues. We have to write the rule that is section 56 like this, like that, and analysis. Here instead of analysis I used the word logical reasoning. Then we have to give the conclusion. ಅಂದ್ರೆ ನೀವು ಇದು ಇಶ್ಯೂ ರೂಲ್ ಅನಾಲಿಸಿಸ್ ಕನ್ಕ್ಲೂಷನ್ ಮೆಥಡ್ ಆದ್ರೂ ಫಾಲೋ ಮಾಡಬಹುದು ಅಥವಾ ಈ PQRLM ಅಂದ್ರೆ ಈ ಮೆಥಡ್ ಅನ್ನ ಸಹ ನೀವು ಫಾಲೋ ಮಾಡಬಹುದು. ಇದರಲ್ಲಿ ಯಾವುದೇ ಅಭ್ಯಂತರ ಇಲ್ಲ. ನೀವು ಇಶ್ಯೂ ರೂಲ್ ಅನಾಲಿಸಿಸ್ ಕನ್ಕ್ಲೂಷನ್ ಬಂದಾಗ ಇಶ್ಯೂ ಸಮಸ್ಯೆಗಳನ್ನ ನೀವು ಬರೀಬೇಕು. ಪ್ರತಿವಾದಿ ಮತ್ತೆ ವಾದಿಗಿರುವಂತಹ ಒಂದು ಸಮಸ್ಯೆ, ರೂಲ್ ಬಗ್ಗೆ ಯಾವ ಸೆಕ್ಷನ್ 56 ಮತ್ತೆ ಅದ ಕೇಸ್ ಲಾ ಅನ್ನ ಬರೀಬೇಕು. ಅನಾಲಿಸಿಸ್ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಅದನ್ನ ನೀವು ಜಸ್ಟಿಫೈ ಮಾಡಬೇಕು. ಅಂದ್ರೆ ಲೀಗಲ್ ಲಾಜಿಕಲ್ ರೀಸನಿಂಗ್ ಅಂದ್ರೆ ಇದರಲ್ಲೆಲ್ಲ ಇಶ್ಯೂ ರೂಲ್ ಬಗ್ಗೆ ಎಲ್ಲ ನೀವು ಸಂಪೂರ್ಣವಾಗಿ ಬರೀಬೇಕು. ಕನ್ಕ್ಲೂಷನ್ ಅಲ್ಲಿ ಎಸ್ ಆರ್ ನೋ ಅಥವಾ ಅದರಲ್ಲಿ ಪೂರ್ಣ ಒಂದು ಆನ್ಸರ್ ಅನ್ನ ಬರೆದು ಅದಕ್ಕೆ ಜಸ್ಟಿಫಿಕೇಶನ್ಸ್ ಅಂತ ಬರೀಬೇಕಾಗುತ್ತದೆ. ಸೊ ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಕಸ್ಡ್ all the steps, provision of law, question of fact, question of law, that is issues. Here all the things are one and the same. Here next one is we have discussed the rule of law. So the settled law, court of judgments and decided cases, and we have discussed the logical reasoning. Last one is mature judgment of our conclusion. Here what we have to write, the plaintiff cannot succeed, he cannot claim damages due to doctrine of frustration. And here instead of all those things, the other methods also are also there. Here that is ILAC method is there, fact, issue, provision of law, analysis and decision or reason for decision making. So here so many methods will be there. Probably in majority of the colleges it will not be taught. So students, you can solve these questions with the help of this table. And if you could not able to solve the problems, you can just message to our channel. We can able to solve all the problems. So you can look into the other important case laws under Contract-1 with regard to the certain concepts. This is for your reference. That is under offer and acceptance you have to see RA versus FASI and Balfour versus Balfour and Idea versus Range, Collier versus Smoke Ball Company, likewise revocation, Dickinson versus Dodds and Friedel versus Atkinson. Capacity, that is famous case law, Mairi Bibi versus Dharmadas Ghosh. And next one is voidable contracts means Derry versus Speak, undue influence, Alcott versus Skinner, misrepresentation, Benraman versus White, Mistake, Kandi versus Inse. Consideration means Thomas versus Thomas. President of marriage, Venkata Krishna versus Venkatachalam. In this question, number of examples will come in the examination. I hope I can solve tomorrow if possible. President of trade, Nordenfeld versus Nordenfeld company. Breach of contract, Breach Frost versus Knight Rochester. And next one is doctrine of frustration, that is Taylor versus Caldwell, and Satyaprada Ghosh versus Mungiram. And maintenance, Ashley versus Reynolds, Fisher versus Kamla Naikar. Penalty and liquidated damages, Hadley versus Baxendale, Fatehchan versus Balakrishna Das. Quasi contract, that is Ryder versus Whomwell. And unjust enrichment, that is Damodar Murliar versus Secretary of State. So this is for your reference from the examination point of view. It is very urgent, so I have done it. If you follow this table, definitely will get the marks. Either it may be for under 80-20 scheme or for the under 100 marks. So this is the one example today we have solved. If I find time, I will do the rest of the problems from the question paper. Students, do not neglect the illustration problems. You are going to lose the marks in this illustration problems only. Probably the students think that the university is not giving the marks, but you don't follow the steps. How the valuer can give the marks? If you follow the steps, if you write the required information, definitely you can get the marks. Probably you can think over this matter. So what is the option now left? You have to solve the illustration problems only. That is the only option left for you to score. Now, not only passing marks, you can score very higher marks also. Okay, students, wish you best of luck.